Still need a final pre-trial conference, actually. People asked.
Yeah, there's been
Oh, that's it.
yeah.
Okay,
Yeah.
sorry.
Yeah.
So we do a final trial conference and not.
And we're on this,
But I mean,
not to be flip about, but if the parties feel the need that something has to be brought to the court, discovery issues out there, just ask them to bring something up and we can get that.
I know I'll have a motion for funds very shortly.
That's fine, we'll just bring it up to them. Okay? All right, Council, thank you.
The Chairman's motion for Gale has been taken under advisement. This matter is continued to July 28th, 2026 at 2 p.m. for final pre-trial conference.
Thank you, Madam Clerk. Thank you.
Thank you.
Your Honor, the next matter we have before the court is Commonwealth versus Lindsay Clancy. Ms. Clancy is present by way of Zoom. She is represented by Attorney Kevin Reddington, and the Commonwealth is represented by Assistant District Attorney Jennifer Sprague and Assistant District Attorney Shannon Butler.
Good afternoon, Council. Hi. Good afternoon, Ms. Clancy. Can you hear me all right?
Yes, good afternoon, Your Honor.
All right, great. All right, so we've got a number of matters that are on. So I thought the best way to deal with this, number one, I want to kind of find out how, I know the evaluation was scheduled a week or two ago. Kind of see how that went. And I know there were some discovery motions that were filed by the defendant. I know there were some Rule 17 motions that were filed by the Commonwealth. And then maybe if we had a couple minutes, we could talk about a little bit about the procedures. I know there was some suggested voir dire questions. I know it's early, but it's never too early to start talking about jury selection. So I guess first off, any issues arising out of the Commonwealth's evaluation of Ms. Clancy a couple of weeks ago?
No, Your Honor, two of our doctors evaluated Ms. Clancy over a 3-day period. The third doctor that we have retained is going to do a Zoom interview with Ms. Clancy, and we made sure that his doing that separate interview wouldn't impact the timing of his report or delay the trial in any way, and he assured us it wouldn't. So we're getting some dates from him to coordinate with defense counsel to get that done. But I think we're on track in terms of the evaluations and when we'll have reports.
All right. Mr. Reddington, any issues that you saw come up during those evaluations?
No, they went very smoothly, thank you.
All right. So that then kind of begs the next question in regards to those reports. Do you have a time estimate that the three of you have talked about?
I believe what we had talked about in court before was end of May, beginning of June.
Okay. All right. So that first issue seems to be resolved or on its way to being resolved regarding the evaluations. Now, about the discovery motions. The parties ready to argue those?
Yes.
All right. And so I've got, I think there were two. I don't know, were there any more than?
I think there were two.
All right, because I was coming from out of county, so they were clerk's office was good enough to forward those two. I just wanted to make sure I had those. So I have the first one we can take up maybe is, it's called the motion for discovery regarding communications. Mr. Reddington, I'll hear you and then I'll hear from Colin.
Your Honor, I'm cognizant of the case that came out. It actually came out of this county. I believe it's Commonwealth versus Caldwell. It was a rape case where the gentleman was in jail for almost a decade, and there had been a number of post-conviction hearings before various judges denied as far as the defendant's request. But then ultimately, on a Rule 30, it became apparent that there had been exculpatory statements made that were known to the prosecution. I'm not suggesting for 1 minute that I have any information that appeals, notes, memoranda, coterminous with discussions that might refresh someone's recollection. I am cognizant, I filed this motion on, I read a case up in Newburyport a number of years back, interestingly enough, where the issue of ballistics was in play, and it ultimately resulted in the production of an email from the prosecutor to the ballistician saying, please, 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 I have to have you hook up this bullet or I have no case. So needless to say, that resulted in a defendant able to raise that issue with the court. So I'm asking that the court would enter that order. And finally, I'm asking that if it relates to text messages, and I hate to even mention the case, but the Karen Reed case, where that detective, his personal cell phone was utilized, not his business cell phone. So I would ask that the court would enter an order that personal or business related cell phones, computers, tablets would cover under that order.
All right. Colin.
Your Honor, I would object to this motion. We are well aware of our obligations to turn over any exculpatory information, and if there was any in this case, I would certainly turn it over. But I haven't found any. So I will honor that obligation going forward. Despite the changes to Rule 14, work product is still a thing, and all of what defense counsel has mentioned is work product, unless or until there is some exculpatory information or a statement by a witness that we would, of course, turn over. As far as personal phones, I don't use my personal phone for work purposes, so I would object to anyone having access to my personal phone. But in general, I would just object to this. There's no foundation, no basis, no information that any exculpatory information has been withheld, unlike cases post-conviction where there is evidence that is brought forth and then motions are allowed for this type of discovery. But that is not the case here, and it will not be the case here because we will honor our obligations under Rule 14 and our ethical obligations.
So, Mr. Rankin, you're looking for evidence kind of beyond Rule 14, so kind of a Rule 14 plus?
Yes. Communications, for example, if there would be text messaging between, and I use the example of a particular victim witness advocate and a doctor, or the doctor communicates with someone from the DA staff regarding an issue that arose during the course of the alleged independent evaluation, anything like that I'm looking for. And that would be, as I said, based on Mr. Proctor, former Detective Proctor, I think personal devices would have to be included. And I'm not trying to be invasive to anybody's privacy by any means, but that is an issue that was brought to the fore significantly during that trial, so I do include that request.
And I think that became an issue when evidence of such matter became known, and then that opened the door to that type of discovery, which is not the situation here.
All right. I'm going to take that under advisement. I've got to go back, review Rule 14. As part of the prosecution team, and Rule 14, I think, specifically mentions victim witness advocates now. But I also then have to review the work product kind of statement. I'm going to take a look at Caldwell. So I'm going to take that under advisement.
Okay.
Let me see. All right, the next motion is for discovery regarding government's medical witnesses.
Could I just say, I apologize, you're under the site for Caldwell, it's Commonwealth versus Clifton Caldwell, it's 487 Mass 370.
That's all. Thank you. All right. So take a look at that, especially in light of Caldwell. And then regarding pleading number 74, which is the motion for discovery regarding government's medical witnesses. So, Mr. Ray, can I lay on that?
Your Honor, in that motion, I'm asking that the court would entertain a request that we be advised of the cases that the government's chosen doctors have been involved in a criminal case, certainly not during their entire practice. When they are engaged government or the defense, requesting information as to the percentage, if you will, of their practice how much percentage of their practice would be for the prosecution, how much for the defense, and then obviously the name of the cases or docket number and references in the event there was testimony, not so much a plea. I'm not looking for, the government to provide me with their reports on these cases. I'm looking for the name of the case, the court location, the docket number, and whether or not they testified for the government or the defense. I'm also looking for, I think there was some other request. I don't have the motion in front of me.
Yeah, there was the fourth paragraph was directing the physician to produce and make available to the defense notes, records, memoranda.
Yes.
So I think that was in addition to
Refresh
this.
my memory, Your Honor. So obviously, and I don't know, maybe there are none because of the fact in this case, as you know, we filed a motion to have the interviews recorded, which they were recorded. So I don't know if that obviated the necessity of anybody taking notes. A lot of times the doctors will say that interferes with the relationship between the patient or the defendant and the doctor who's doing the evaluation. So those are the requests that I have in that regard.
So
I specifically did not ask for the amount of money that they have made, and the reason is that I personally feel in the cases I've tried, I can literally tell you, never have I ever asked a doctor, expert, anyone, how much money did you make in this case? And I always say, in the event the government asks the question, I always say, look, everybody's getting paid to be here. I'm getting paid, the judge is getting paid, jurors, not much, but they're getting paid. So it doesn't really matter what the funds are that they receive. I don't really care how much money they made. I don't think that's going to color someone's testimony at all.
I guess what I'm interested in the argument because it's above and beyond the CV that's supposed to be or by rule has been I imagine it's been turned over. It's going to be turned over. But then to ask them to go into their records and go back and dig through all that.
Well, it's not so much a matter of digging through all that as much as like when you get the CV and the CV says the following are cases that I testified in, and they name the cases, but you don't have a docket or you don't have a specific. I can't go hunting through the internet to find what case they're talking about. So I look for a docket number or location of whatever court it may be, Pinellas County, California, or something like that, or a docket number. And then I can try to see if there would be any records or documents indicating that what their testimony was. They don't give you that generally on a CV.
Call.
Rule 14 only requires the curriculum vitae as well as any publications that they've authored. We've turned over the CVs for the two doctors who have already done the analysis, and we'll be turning over the third doctor's information tomorrow, and those contain the publications they've authored. This is all above and beyond what's required by the rule. There's nothing in the rule or in the case law that requires us to go on a search for this information. If defense wants to use it in their cross-examination, then they have to go and find it. We're not required to help them with their cross-examination. Unless there's something exculpatory and we find that, we will, of course, turn it over. I don't think Rule 14 requires me to do math either, so asking for the overall percentages of cases. And if anything is allowed, I'd ask for the same reciprocal discovery from defense counsel on his witnesses. But in the Commonwealth's position, this is all well beyond the scope of Rule 14.
So I can assure you that I know every article that these guys have written, and I've already gone all the way back to their high school. I really don't need the government to help me on cross-examination, but I don't think it's an unreasonable request to say that when they put on their resume or their CV what cases that they've been involved in, to know whether they're testifying for the government or the defense and some docket number. It's not requiring a lot of work to find a docket number or a court that it's in.
Defense counsel can do that same work.
I don't. It's kind of hard for me to make this determination without seeing the CVs. Do you know what I mean? It may be, if I see them, it may be not a big ask to fill in these gaps, or it may be a huge thing to ask. I mean, if somebody's been an expert for 25 years and there's nothing on the CV about the specific cases, that's a big ask for somebody to go back through 25 years of your career and reconstruct what cases there were, that. Now, so that's just one comment I had when I was reading through that. The other thing is, I guess, I'd be interested to hear from both parties. Everybody, and I always ask that question, right? What percentage of the time that you've testified were you on behalf of the government or the defense? That's very common. I mean, I ask that question many times. And is it, I imagine, is it a big ask to kind of ask that question in advance from both sides, that everybody would know? If you feel it is a bridge too far in a sense, let me know. But I'm just thinking, we've all heard that question, and if everybody knows what the answer is going to be now, is there a problem? Because then if somebody says it's 10%, well then the other side may want to do their own chasing after it, or not. They may be satisfied with that. I don't know.
I think it's beyond the scope of Rule
Right.
14, and I think it is a significant ask because we then have to go to the experts and ask them to review every case they've ever worked on and determine which side they were on, and then do the calculations to determine the percentage. And really, it's not the quantity that's important, it's the quality of the work, and I think that can be examined in the cross-examination without knowing an exact percentage.
But don't you think you're both going to, I shouldn't say this, it would not be a surprise to me if that question was asked by both sides of anybody who testified here.
Well, I think there's two separate issues here. I mean, there are plenty of questions that might be asked of a witness, but it doesn't mean the Commonwealth has an obligation under Rule 14 to seek out that information and provide it.
I was just asking. I just kind of wanted to know what the Commonwealth's position was in regards to that. All right. What I'm going to do is I'm going to take no action on this at this point, because what I want to do is maybe see the CVs. So I would then know what information both sides, because if I'm going to do one, it certainly would be reciprocal in regards to these requests. But I'm not saying I would. I just kind of need a little bit more information as to what the CVs have presented.
So I'll get the CVs from my side and present them to Dawn, and she can make.
Yeah.
And I can do the same.
All right, and I'll take a look at them, then I'll make a decision on this regarding that. All right. All right, so I'll take that matter under advisement as well. Now, the next series of issues, I think, is in regards to the Rule 17s.
Yes, and I believe Defense Counsel is not objecting to those.
All right, so it's a request for Mass General records. And then there was one, I just kind of wanted to make sure I had it.
Right, there's one for employment records from Mass General, there's one for educational records from Mass General Hospital Institute of Health Professionals, and then there's one for educational records from Quinnipiac University, and accompanying that should be a certificate for out-of-state securing of those records.
So the MGH Institute is an educational, just kind of continuing education in a sense if you're working at Mass General, something
Yes,
like that?
they offer a bachelor's and master's program in nursing.
All right, so I'm going to allow those.
Yeah, I have no objection to that. I know they already obtained a number of documents and records from her employment where they were peer review ratings and things, and she always aces everything, so I have no objection on that.
Do we need a return date in regards to those records?
Yes, and specifically for the out-of-state records, because there are spaces on those documents for a return date. We could do a 60-day date.
So we've got a June date anyway, don't we,
Right,
already?
yes. We have June 18th.
Yeah, June 18th, Thursday.
You want to put that as the same date?
That'd be great, thank you.
That way, if there's issues we might as well deal with them. If they're not, then we know we can just kind of check that box. All right. So we'll allow those with a return date of June 18th.
Okay.
All right.
Thank you.
Next issue, there was a request for release of the juror list. We had early. I allowed that, so I figured it'd come in here. So the parties have those.
Yes.
Okay.
Thank you.
Thank you.
Then, just maybe a little discussion regarding the impanelment procedure. I know that there was filed a suggested questionnaire along with a number of questions. We're not going to go through them. I mean, I think it's early, but it's like I said before, it's never too
Well,
early to
it's
start.
never too early, and I just figured that, so council has it, you have it.
Yeah.
You can add, delete, deny, allow.
No, I think that's what I'm saying. I think that's helpful. In the Commonwealth, the same thing as we go through it. But generally, try a case with everybody here. So, generally what we do is I'd ask general questions. And a lot of the questions are here. I'll ask generally, and then we'll just get an individual sidebar, kind of as we go through it. And then, as we've done before, I'd ask you to exercise your challenge at that point rather than like the old days, fill the box. And then, and so there's some questions in regards to the procedures, so that's generally the way we do it. If we do a questionnaire, my hope would be to keep it to one page. Because I just think that it's easier for the jurors as well. But we'd still have individual voir dire no matter what.
So can I just question, when we do the individual voir dire, what's your practice? I forget, I've had many cases with you, but do you have the jury in the witness box and counsel stays at the table, or do you go up to the sidebar literally?
I generally go over to the sidebar.
So my request, if you would consider it, is that we use the witness box with the juror for a couple of reasons. I know there are many judges that do that, and not to mention the fact that it's a lot easier on the legs than standing there for hours on end at the sidebar. But my client, as you know, is in a wheelchair, so it'd be kind of difficult where I always ask that the client be with me at the sidebar when we have that questioning of the jurors. So I just ask in this case that you would consider doing it through the witness box, just because it's going to be difficult.
Right. And I was thinking of that. One of the other possibilities is to use the what's it called, the whisper, like the headset.
If that's your order, that's your order. But
No, I haven't gotten it. I haven't really done it. I'm trying to bounce off the different ideas. That's one thought. And one of the reasons why I'm not necessarily a big fan of the witness box in a case like this, there's a lot of really personal questions that are going to be asked. In not just this case, in a lot of cases. And that's why I generally would do that.
yeah, but there would be nobody else. I mean, as far as
We can't close the courtroom.
so.
Right? I mean, you look at is, Cohen versus Cohen. Cohen versus Cohen, which Cohen won, as I'm familiar with. But that's one thought. We can talk about, this is probably a better specific topic when we come back in June. But I just kind of wanted to get that out there, have people thinking about it. How are we going to do this? I'm not wed to that. I mean, this is a unique, each case has its unique characteristics, and this may have that scenario where we have to do it in the juror box. I just haven't really kind of finalized
I just
it.
know that I've had many cases in various counties where judges will do the individual voir dire from the jury box. It works out well. I've never had any issues that I can recall in those cases. I know the court's got to balance the concerns, but I've done that whisper thing in federal court and state court. I don't like the whisper thing.
I never use it. I'm almost because I don't like it either.
I tell you.
But sometimes it's, as bad as it may be, it's better than the alternative, as they say.
Well, not from my client's point of view. My point of view, I understand you're balancing other people's interests.
No, I understand. Come up with any thoughts?
I prefer to do it at sidebar. I agree with the court about the personal questions. I think we're more likely to have jurors who are comfortable and honest answering at sidebar. We also send them out of the room to do our challenges, so defense could use that opportunity to speak to the defendant. But I would defer to the court on it.
All right. I'm going to think about that. And then maybe we come back here in June, have a better kind of concrete answer. I'll have to kind of decide how we do it. But I kind of wanted to just gauge everybody's thoughts and interests and position. So,
Well, the other alternative is we could ask the court officer to construct a platform that we could put next to the bench, I suppose.
that's another possibility. So we'll keep all possibilities. But I mean, generally, we either do it sidebar there, maybe with the whisper, but we'll weigh those out. All right. And then fine. So we've got the June 18th date, and then do we need one more date in May? Do you think, to just kind of make sure everything's on track?
That makes sense.
I don't know. I mean, it sounds like things are going. I don't see any big bumps in the road here, but that's sometimes
My
when
only concern is
we
it's
get.
going to be difficult. They have 2 back-to-back federal trials in May, and it's probably going to wipe out most of the month of May. So just let you know that up front, but we can go through some dates if you want.
Why don't you give us a
Sure.
date we can maybe work? It's more of a, I hate to use the word status, but that's kind of what it would be, to see if there's any issues that anybody sees that we need to address earlier rather than later when we come in.
Well, May 21st is a Thursday in the morning.
It's fine? Yes.
And if that becomes a problem from either side, just let us know. We can kind of release it. And that's really just to check in regards to discovery, witnesses, and any other issues that we may have. Well, Leslie, could I see counsel at sidebar just briefly? Anything further we need to address at this time?
I don't believe so, no.
All right, Mr. Reddington, anything further?
No, thank you.
All right, so this case will be over until, what was it, May 21st.
So for the record, this matter is continued to Zoom?
Yes,
Thank you.
Basically,
yeah, I did.
you said 2
Oh, I can get it, I have to be in federal court in the afternoon.
I'll do it in the morning.
Do you want to move
Yeah,
it?
we do.
Okay.
Let's see,
Whatever's good for you.
want to say 9 o'clock? Because I don't know what Judge Hogan's trial schedule, may have to sneak in
Oh, I see, okay.
there first, then head out to where I'm going. And then, like I said, if we don't need that date, parties can just let us know.
Okay.
And the thought then on that June date, just so everybody, transportation and everybody else, the thought would be to have Ms. Clancy here in person on the June 18th date. Okay, all right.
So for the record, this matter is continued to May 21st, 2026 at 9 a.m. And Ms. Clancy will appear on Zoom.
Thank you.
Thank you.
Thank you.
All right, thank you, everyone. Thank you, Ms. Clancy.
Mr. De Laurent is present. We have also probation officer Lauren Hanley is present. There is no
Thank you, everybody. Sorry about the tech.